Everyone, and welcome to PilieroMazza's annual review, Workforce Updates for Multi-Jurisdictional Employers, What to Watch in 2026. I might give people 1 minute while we're doing a little intro bantering to filter in. They won't be missing a whole heck of a lot, but we do want to welcome you to the webinar. I know it either feels like the year just started, or I can't believe that it's already halfway through February. But in any case, it's good to be here with you and thinking about trends and issues for you to spot in 2026. If you have employees in many different states or even outside of the United States, or if you're thinking about picking up contracts where you will have employees in multiple states. And with that, I am Nichole Atallah. I will introduce myself. Next slide. I have been working with PilieroMazza, I don't know, most of my career, 16 years now, something like that. And counsel employers, both Sarah and I counsel employers on all sorts of issues. I'd like to call us general counsel for companies on labor and employment. So nuts to bolts, labor and employment. We also specialize in that intersection of government contracting and labor and employment and multi-jurisdictional employers. So that's kind of our sweet spot. Sarah?
Yeah, and I'm Sarah Nash. I work side by side with Nichole on all these labor matters. A lot of multi-jurisdictional issues have been coming up over the last, really, since we've been doing this. It just seems like COVID sort of increased the extent to which companies are willing to sort of spread out their workforce a little bit. So we've been dealing with a lot of these questions over the last few years. And last year we did a series of webinars on multi-jurisdictional questions that have come up frequently. So we thought, as we were looking at 2025 and trying to figure out what's happening in 2026, Nichole and I are like, well, it's all about these questions about what laws apply to the workforce, and it'd be a good idea to get out ahead of it and join together on another webinar.
Mm-hmm. So if you're not familiar with PilieroMazza, we are a full service business law firm. We are a strategic partner, not only to government contractors, but to businesses that work across the spectrum of industries. Here's a list of all the things that we kind of do. My guess is it's even broader than that now. But we're very proud of our team and very happy to be able to be here today. So if you're not familiar with us, please check out our website and let us know if there's anything that we can do to help you out.
So today we're going to be talking about just a lot of the issues that we've been seeing again over the last few months and going into 2026. We'll talk about some of the major federal changes, but spoiler alert, most of the changes are state specific. I think more now than ever, we're seeing a really slow uptick in federal laws that applies to, commercial businesses and federal contractors alike. And more we're seeing just updates at the state level. So a lot of today is going to be focused on how those changes are impacting companies, how there are some questions about sort of the difference between federal law and state law, and how you can override some potential conflicts between the two. And then we're also going to be kind of giving some suggestions for how, if you are a company that has employees in a lot of different places, how do you stay sane? Because this stuff is coming at a really quick clip. It's hard to anticipate sometimes. There are some states that pass legislation, and then next thing you know, it's been rescinded. And so you can go a little bit crazy. And so we're going to talk about some best practices for how to stay ahead of that. And just understanding trends in general. I think it's important so that you know how to issue spot, when you go into a situation, what the potential ramifications are, and just hopefully this can provide you with some good tips for if you do run into situations, you're like, oh, I know about this. I know how to get ahead of this. And it's important to be strategic in how you're thinking about these things as opposed to retroactively sort of figuring it out. We also are going to provide some tips. I mean, it's hard because ultimately there's no magic bullet. Clients ask us all the time, isn't there just a service that can do this for us? And trust me, we've looked, we haven't found anything that's really reliable, especially because so many industries are so unique, government contracting, other industries, that it really depends on sort of the nature of the business. And it's just hard to keep up with these trends. But that's what we're going to go over the next hour or so. We've got a lot of material. And again, the point here isn't so that you walk away knowing all of the answers, is so you can issue spot and know that it's out there. That's ultimately, I think, the main point of what we're doing here. I will also note that this is eligible for HRCI. So between Nichole and I, that one of us will remember to give that code out at the end of the hour. No, it's good.
We our back of the webinar support, Miss Kaylee, will also,
or Kaylee, yes,
help us remember. So that is a weak spot I have. So
me too. So yeah, let's dive in and we can talk about some of these sort of trends that we're seeing. Nichole, I've completely forgotten who's doing this slide.
that's okay. I can jump in. So as Sarah kind of alluded to in the last slide, these are some broader trends shaping kind of workforce regulation. And the theme of today is really, the federal government isn't doing a lot. There is some enforcement action they're taking, which we'll talk about a little bit later. But because they're not doing a lot, states are stepping in. And so we're really seeing this shift towards employers having to figure out how to comply with multiple jurisdictions. And you have people that just move. People like to move now, and people are hard to replace sometimes. Sometimes they're not a fungible asset, and employers are more willing than ever to stretch in order to keep, certain people with their company. So that is definitely a trend that's impacting workforces. We're going to talk about, what the administration is focused on and how that's kind of in that enforcement is really where they're focused on, and how they're focused on enforcing current laws is different than you might have seen in past administrations, even Trump 1.0. That the administration's focus on enforcement has both broadened in some areas, broadened their scope of the way they're looking at certain laws and enforcement of those laws, how it wants to change interpretation of how those things are enforced. We're going to talk a little bit about that. We've already talked a little bit about that increased state and local activity, which is creating challenges. We're also seeing increased union activity, right? So as the workforce starts facing some changes and some tightening in the labor market, and the salaries aren't growing as fast as inflation in many cases, or wages aren't growing as fast as inflation, and that tends to be an opportunity for unions to come in and convince these workforces that unionization is the way that they can protect the power of their wages going forward. We saw a push toward unionization under the Biden administration, and as much as the Trump administration has pushed kind of back against enforcement by the National Labor Relations Board, nothing has changed, right? The National Labor Relations Act is statutory. It's continued to be enforced, and workforces are continuing to unionize. We've seen a lot of labor activity at the end of 2025 and into 2026. And of course, I mentioned this earlier, but as workforces become more hybrid, either because employees are moving to different jurisdictions and employers want to keep them, or because work can be done in more of a remote way, so employers are hiring from multiple jurisdictions, there are unique wage and hour considerations that we really have to focus on there. So that really comes into play with business registration and compliance with local laws, where you can find yourself in court, right? Or under investigation. You could be thousands of miles away, which creates some challenges there as well.
Just to plug quickly, this is like on behalf of our litigation team in particular, I think we've seen a lot more employees who are willing to take cases without legal counsel. And so they're representing themselves because they have access to AI now and AI tools. And I think that's sort of a trend that's going to continue. So frustratingly, it used to be that employees if they couldn't find legal counsel, they would sort of drop their legal sort of battles because they're like, oh, it's too hard to navigate. But we're finding there are fewer sort of obstacles to getting into the courtroom because of this access to AI. So just it's also kind of a riskier time to be an employer across a lot of states because depending on the employee and depending on their appetite for using these resources, we're seeing an uptick in that sort of type of litigation,
Yeah.
unfortunately.
I mean, it's a good point too. We'll talk about kind of AI a little bit later today, but not just in litigation, but we've seen it in employee complaints too, which, is unfortunate because you have an employee in Virginia that chat GPTs something about wages and whether they should have been paid. And it's pulling from statutes all across the country. I saw one last week where the employee pulled something that referenced an Illinois statute. They're I think an Ohio or Oklahoma employee. So they think they have a claim because ChatGPT says the employer is doing something wrong. They do the right thing. They come to the employer, but they're convinced the employer is lying to them, right? And so we've seen more of that in addition to kind of that pro se litigation. So yeah, AI is definitely having an impact not only on your processes internally, but also on how complaints kind of come to fruition.
Mm-hmm. So this is, I think, maybe one of the most straightforward slides that we have of the day. There have been some very specific changes in the federal contractor landscape, and just because we know a lot of you folks on the call are federal contractors, we're touching on this. Just because it's typical that we do this each year, and this is one of the years where we've lost a lot of obligations, which makes it, in theory, easier for contractors. But in practice, we're seeing some interesting sort of consequences to the changes. So a lot of the Trump administration's executive orders were issued early last year, right? So they got rid of the minimum wage requirements. They removed the non-displacement obligations for SEA contractors. And probably the thing that got most press last year was this move away from affirmative action obligations for contractors, at least for women and minorities. And so in particular, one of the biggest sort of things that we've been watching over last year, and it's still developing today, so we don't have all answers, but was sort of this ending illegal discrimination and restoring merit-based opportunity executive order that was issued by the administration in, I think it was like kind of day one, day two of the Trump administration's year. And basically what they did, I know that Nichole and I have done probably webinars ad nauseum about this subject, but it's worth repeating that it revoked a prior obligation for government contractors to create affirmative action plans for women and minorities. In addition to that, which is sort of the bigger ticket item, it declares that sex and race-based preferences are unlawful. In and of itself isn't really earth-shattering because there's a number of state statutes, federal statutes out there that apply that requirement. But it instructs into agencies to terminate all discriminatory and illegal practices and preferences. And that kind of what that entails has been this big question mark since this executive order came out. There's been some litigation where they've gone over, well, does it really mean anything more than violations of Title VII and other EEO statutes out there? But where there's been development in the last few months, I would say, is in how they're enforcing this. And so part of the executive order creates certain False Claims Act implications for violations of this. And DOJ created a task force last summer that is supposed to be looking into this. And then just last month, or maybe it was the end of 2025, DOJ has started these investigations into bigger contractors for the most part. So, Google, I think, is one company, Verizon, where they're actively investigating whether certain policies of these government contractors are in violation of the executive order. And that's just basically looking at DEI that's out there. So we don't know exactly how they are approaching this, but generally their commentary through litigation and other guidance has been that they are looking to enforce basically Title VII obligations and nothing more than that. The idea is you cannot discriminate against individuals on the basis of their race, on the basis of their gender or sex. And that's pretty much been the party line. I think we're going to see a little bit coming out of these investigations, whether they change that approach at all. But for the time being, what our suggestions to companies has been is that you need to have good EEO policies in place, get rid of those AAPs for women and minorities, but remember, you still have certain AAP obligations for your veterans and individuals with disabilities. And just generally making sure that you've buttoned up, have good policies and procedures in place, and that should generally get you through these changes. Nothing earth-shattering, again, just good practices for HR and for onboarding and things like that. There are also certain certification obligations that have attached. We haven't seen, I don't think, a form certification yet. That should be coming eventually, but for the time being, it's sort of been on a case-by-case, agency-by-agency basis. And that certification is basically a representation that you are complying with anti-discrimination laws out there. You want to make sure, as always, that you're reading those certifications. Because they are sort of ad hoc, it's possible that there's other language in there, and you should not just sign, you should push back if there are things, because again, there are potential FCA implications. Jury's out on how those will be enforced, but it is a risk to companies. Anything else on the kind of anti-discrimination piece, Nichole? I know there's a lot of material out there.
DOJ kind of issued its more formal civil fraud initiative, right? That's kind of been more recent. It's more of the same. It basically makes it a false claims violation to engage in illegal discrimination. I think, as Sarah alluded to, the question is really what is illegal discrimination and what's been represented versus what are they trying to enforce. And I think if your perception is that really we're kind of just flipping discrimination on its head because of the way this administration has seen it, it's not really discrimination against minorities and women. I think what you need to think about is that this is really, it's fodder for DOJ, but it's more fodder for plaintiffs' counsel, right? Mm-hmm. So if you are a plaintiff's lawyer and you have somebody walk into your office that says, I think I've been discriminated against, or I think, you know, wasn't given a reasonable accommodation, or my employer for a disability, or my employer didn't engage in, you know, an interactive process with me, they just fired me. All of those are violations of the ADA or Title VII, and plaintiffs' lawyers can use that as a way to not only file an EEOC claim or to move through that kind of demand process, but also say, and by the way, you've falsely certified to the federal government, if you're a contractor, that you're compliant with these laws, which means I have a qui tam action under the False Claims Act where I can recover even more than I'd get before. So it's, you know, I think we get caught up in this whole, like, how the Trump administration is going to view and enforce these things, but there's also, I think, these, whether they're unintended consequences or not, I can't say, but there's going to be this body of, this is why it's really important for you to still have your EEO policies and make sure you have good processes for handling employee complaints, and, you know, processing accommodation requests, all of those things, because it's a bigger deal, I think, now.
Yeah, for sure. And we have seen some demands that reference it. I think this idea that, oh, it's federal contracting, plaintiffs' bar isn't going to figure out what's going on is not really a good protection at this point. The last point on this slide is just a reminder that the FAR has been completely rewritten. As far as labor and employment obligations, not a lot of huge changes, but there are quite a few provisions that have been moved from the FAR to guidance. We'll see how that plays out. Just putting that out there for folks who are tracking those changes. Okay. Nichole's getting calls.
Sorry, I shut off.
Okay, now, Nichole, let's talk a little bit about this is Nichole's side, thankfully, because there have been so many changes, and so quickly we're just going to talk about things that happened in 2025.
Yeah. So what I wanted to really demonstrate in this slide, we would spend way too much time going through every single law that is changed in every single state. But if you look at the changes that happened in 2025 going into 2026, there are definite themes, right? So the first theme are updates to state family and medical leave, and this is protections for a certain amount of paid or unpaid time off, depending on the state. And there were either new state family and medical leave laws or changes to those existing laws. And I listed the states that had changes to their leave laws. Same with paid sick leave. So there are something like, we looked it up this morning, 19, did I get that right? 19 states and the District of Columbia that now have paid sick leave laws on their books. These require employers to provide a certain amount of sick leave. They all have different carryovers, caps, accrual caps, that you have to comply with. And if you're a federal contractor that has SCA or DBA contracts, you also have a federal sick leave requirement on top of that. So keeping track of these paid sick leave laws and how to manage the sick leave laws, we're going to talk a little bit about that later, but it really is important to understand. That's a little bit commingled with this idea of state insurance programs that provide for paid leave. So you have these state family and medical leave laws that provide some, there's like an FMLA at the state level, right? It provides some amount of unpaid leave. Then you've got paid sick leave that provides that employers provide a certain amount of time off for sick. And then the third kind of component of that is states that have a state insurance program where employers are paying often a premium into the state to provide paid leave under certain circumstances to employees. And you got to kind of figure out a way to make all those things work together. So watch Colorado, Minnesota, and New York for changes to either the paid sick leave laws or their insurance programs to provide paid sick leave through the state. There is a new mini WARN Act in California. We'll talk about mini WARN Acts in a little bit here, I think, again, as well, maybe later on. But anytime you're laying off a portion of your workforce, you have to think about not only the federal WARN and whether it attaches, but many states have these mini WARN Acts that have requirements to notify employees in advance of layoffs whenever possible. And the threshold is not 50 employees in most of those states or in many of those states. So you need to, I think I've seen some of the first class actions we've seen in a long time under WARN Act in the last year. So something to really be focused on. Stay or pay clauses, that's a clause that basically is like tries to force employees or discourage them from leaving, right? And so there's new legislation about that in California. AI and human rights in Illinois, I think this is a really interesting development because you're starting to see states try to rein in the use of AI. A number of federal agencies have also put out guidance with respect to the use of AI in handling employment related policies, right? So the EEOC has put out an AI policy, the Department of Labor. Really the crux of this and at the state level is if you are an employer using recruiting platforms or other types of tools to help manage your human resources functions, you are responsible for those outcomes. AI is not, if AI has a bias built into that system, you are ultimately responsible for those outcomes. So you're starting to see more movement to rein in the impacts of AI. Paid breaks are always something that we're watching, right? So there are certain states like Colorado and California that provide for paid breaks, but you're starting to see Illinois has a new requirement for paid lactation breaks, and Minnesota a new requirement for meal and rest breaks. So watch for those if you have employees in those states. They can be great fodder for plaintiffs' lawyers to get a nice little class action lawsuit together. So make sure you're handling those in your policies. Medical donation leaves in Rhode Island and Oregon. So always watching to see kind of new protected leaves. Often these are unpaid leave, but you need to watch your policies to make sure how would that be treated under the Fair Labor Standards Act if it's if you have a salaried employee that needs to take a day off for medical donation leave or a week off, how is that going to be treated? So watch that. The Crown Act in Pennsylvania really deals with discrimination based on hair texture and hairstyle. It's not the first law of its kind, certainly in the United States, but it's interesting that it's coming out of Pennsylvania. So something to kind of watch there. And a couple of different changes to unemployment benefit insurance during labor disputes and how those things are handled in Washington State and Oregon. So what I'd like to say about states is, as Sarah mentioned, it's a lot to update on an annual basis. So what I tell clients to do is think about checking it twice a year, at least once a year, to see what's going on. And anytime you hire an employee in a state that you haven't had people in before or recently, you should, reach out to us or your counsel to determine if you need a supplement to your handbook.
Absolutely. We've gotten a couple questions. Please keep them coming. The only reason I don't think we're directly addressing them is because they are so perfect, these questions, that we are actually planning on talking in them because they're really topical. So have no fear, we will get to those. And we also welcome additional questions because I think this is always more interesting when it's a little interactive and we get real world examples. However, another disclaimer, this is not legal advice, this is a webinar. So if you have specific things to your company or your business, happy to connect online. Okay, so we're going to talk about, because this is a lot, and even all of those updates that Nichole just went over, that's only a handful of the changes. You've got all these states making all these changes. How do you stay ahead of it? What we've done is we've broken it down into a few different kind of subcategories that we'll go through, the types of things that come up that are really higher risk issues for companies that you have to be strategic in how you're navigating. And we'll provide some tips for how you can draft your handbooks or your policies in such a way to sort of accommodate the shifting workforce that we've got. But some of the biggest kind of issues that we've seen with companies is, just that. How do I prepare a handbook for a shifting workforce? How do I make sure that I know where my employees are? These are all things that are excellent questions and important to think about. Generally, when it comes to drafting a handbook, you have a couple different approaches. One is to just narrowly tailor every policy that you have to the bare minimum requirement on each state basis. As you can imagine, that can be a little bit overwhelming because you could end up, if you have employees in 50 states, you have 50 different rules that you have for sick leave or that you've got for different various aspects of your workforce. Another approach is to say, I'm okay spending a little bit more money, giving employees a little bit more than what they're entitled to, if it makes it easier to administer. And so I think that's sort of one of the primary things that you have to figure out, just how willing are you to cater your policies to the state specific, because I'm going to do it. I promised Nichole I wouldn't name drop, but I'm going to name drop California because it's one of those states. So California, like if you want all of your policies to be compliant with California, you want all your employees to have those same benefits, probably chances are that you're going to check a lot of the boxes out there. Not all of them, because there are different variations, but that's one approach. You can just give employees a little bit more. That can kind of help navigate the headache. But again, that can be more expensive in some respects. And so it's just a strategic thought process that you have to think through. It's also important that you keep track of where your folks are. I've talked to a number of clients over the years who say, this employee just moved. I had no idea. And now they're there and I'm stuck with them. And my response is often, first of all, do you have anything in your handbook that requires employees to update their address? Not that you need it in order to make this expectation of them, but it's helpful. It's helpful to point to, you were supposed to let us know this is a violation of company policy. And the next thing I'll say is, and this sort of takes people by surprise sometimes. I don't know, Nichole, if you have the same experience, but it's not illegal to discriminate against Californians. It's not illegal to discriminate against New Yorkers. You don't have to hire in states where you don't want to perform business. And that can be difficult, right? Because Nichole mentioned at the top of the hour, Some employees are hard to replace. They're really valuable. You want to work with them. And that's a decision that you have to make. But by no means are you forced to, conduct business, because that's essentially what you're doing at a certain point in a state or a jurisdiction where you don't want to be there, or you don't feel like you have the information you need to be able to make that decision. So it's important that you're thinking strategically about where you're willing to hire folks and where you're willing to allow people to move. We'll also talk a little bit through these about the intersection with state and federal law. We didn't talk about this in the federal contractor slide, but one of the questions that's been coming up in that AAP world is a lot of states have state-specific AAP obligations for women and minorities that are, in some respects, inconsistent with what the Trump administration has said that they are going after as a legal DEI. And the Trump administration, DOJ just kind of went after one of the states, I think is Minnesota, that has those AAP obligations. And so they're battling that out. We'll see where it falls. But for the most part, most of these state requirements are in addition to the federal obligations, and there's not a lot of inconsistency. Okay, let's jump in. I think that's it in sort of key challenges. We're going to talk about what's out there, and then I promise at the end of this 30 minutes, we'll also talk about some best practices that can help you stay sane if you are in this world where you're trying to figure out all the different moving pieces. So starting it off, hiring considerations. And I cannot stress enough how important it is to figure this stuff out before you start interviewing your folks. The reason being, for pay transparency purposes, those laws can apply before you're even in the state. If you decide, I'm going to hire someone in Washington State because they responded to this ad and they seem really qualified, you could unwittingly walk into a violation of Washington State's pay transparency requirements. These pay transparency requirements, for those who are familiar, basically require certain companies to share expected pay bands or pay and benefits to people who are interviewing. And there's a lot of variation across states. My goal here is not to tell you every single different nuance, although I think we have done a webinar in the past, so you can go find that if you're curious. But there are a lot of differences, and it's important to know the specific state challenges. For example, if you're in DC, they have one of the most aggressive pay transparency requirements, whereby you are obligated, if you have any employees in DC, you as a DC company need to be including that pay band in your job posting. Period, full stop. That makes a lot of contractors and companies grasp their pearls, but unfortunately that is the law as it's currently drafted. I haven't seen a lot of enforcement there, so we're not sure exactly how aggressive DC is going to be, but there are a number of states that have similar requirements to post those pay transparency obligations. And it's not enough to do it after the fact or just individually when you hire someone. It often is a requirement that you do it in the job posting itself. Again, it varies. If those of you remember, there was a plan to introduce pay transparency to federal contractors. That executive order was revoked, though. Was it an executive order? I think it was. And so that obligation is not out there anymore. It would have almost been nice. It would have leveled the playing field, but now you got to navigate the state laws instead. So before you're even deciding who you're going to hire, you need to be thinking about where you're going to be placing people. And there's some ways you can get cute. You can exclude certain states, but it could, cost you some talented applicants. So important things to be thinking about, talking about with your recruiting team. Drug testing is another kind of hot topic issue that's very different across states. Most of it relates to really marijuana testing. There are a number of states, I think there are like 45 states at this point, who have either legalized medicinal or recreational marijuana or CBD of some sort. And so a lot of states are also legislating in this area, trying to figure out how they can have this legalization and work with other federal obligations. And marijuana is still an illegal drug, although there was an executive order that was issued last month, maybe dialing back its level of Um, I really want to say level of drugginess, but I know that's not right, but that's how I think of it. So there are a number of states that limit companies' ability to test for marijuana. Some of them say you can't test for it at all. Others say you can't take adverse action based on a positive marijuana test. Just important that you are considering these. And just because you're a federal contractor, for those of you on the line who are federal contractors, does not automatically give you an excuse or an exclusion from that requirement. So just really important to look at those state testing limitations. I'll also add that there is some case law, depending on the state that you're in, that also creates additional protections for employees for medical marijuana use. So regardless of whether or not you're in a state that has come out and said you can't test for marijuana, it's always important that you go through that standard accommodation sort of questions that you might with someone with a disability who might have medical marijuana prescription. Make sure that you're looking at that and the state specific requirements. And I think that's it for the first two items, at least.
All right. So next we're going to have non-compete and non-solicitation challenges. So if you are a company that has non-compete or non-solicitation agreements with your workforce or with just your executives in your company, it's always good to add this in addition to your handbook to kind of the list of things that you need to double check when you are hiring someone on a periodic basis to make sure they're still enforceable, to make sure you kind of have the latest and greatest agreements. I always like to think of having the tools in your toolkit to protect the company, and that is usually a combination of carrots and sticks, right? So you want to have some good, benefits, bonus programs, things like that to really incentivize people to stay on your team. But sometimes you can't compete with something better that's out there, or somebody who kind of is dissatisfied with what they're doing. And so you want to have some sticks in your toolkit to protect the company from unfair competition. Not trying to protect fair competition here, just unfair competition. That business development person has your secret sauce. They have your client list. They know everything you're going after, and their best play to get a new job is to say, hey, I can bring all this work with me, right? So we are looking, states are increasing their legislation of non-compete and non-solicitation agreements, particularly for lower wage workers. So a number of states have requirements that you can't enforce these against low wage workers. So managing that, we have some ways that we like to handle that so that you're not always trying to figure out what the wage limitation is and when can I put it in place or when is it enforceable. I think realistically people are hired, they kind of get their new hire documentation and no one really looks for a long time in a lot of cases. But it's always really unfortunate to get that call to say, well, we have something in place, and then our team looks at it and says, this is just not enforceable in the state. If we'd only had this one line or this little piece of language, we might have been okay, but it's just really not enforceable. So make sure that if you are a company that, is trying to protect, particularly at the key employee at stage or at the C-suite stage, that you are looking to make sure those non-competes are enforceable. Many states require I wouldn't say many states. There are probably a handful of states that require advance notice prior to signature. So sometimes, there are a couple of states that say 10 days before you require somebody to sign the agreement, they have to be given the agreement to consider before hire, or you've got to give them a certain amount of time to consider it. Those things are easy things to check before you do a rollout of, a company employment agreement, NDA. We also call them PIIAs, proprietary information and assignment agreements. It's got some good stuff in there that you might really find helpful. So for example, some of these agreements, even if you say, you know what, I don't really want to non-compete, Nichole, that seems a little heavy-handed for our company, but I'd really like to make sure we have a non-solicitation of employees and customers provision. I'd really like to have a provision, a contractual provision for the return of property. that will allow me to get my attorney's fees if I have to go after somebody for, not returning their property, their laptops, things that the company car even, I've had that happen before. I'd like to have a duty of loyalty provision. So if somebody, starts trying to gut my contracts from within, I have a mechanism to go to a court and get an injunction quickly. Pay deduction authorizations, right? We'll talk about that, I think, a little bit later as well. But there's some stuff that can be in these agreements that are really helpful. But again, you have to make sure that you are compliant in the states often where those employees are working. That's really the state that we're looking at. We're not just like, you can't just say, well, I'm a Maryland employer, so Maryland law applies. That's not how this works. It's usually the state where the employee is working. So we want to make sure that what you have in place works in those states. You also want to be thinking about things like class action waivers, particularly in high-risk states like California and Colorado, because class actions are really where it gets expensive. So having those in place are really important. Classification is also very, very important. I cannot overstate enough that this is where class actions happen. Mistakes that are made in classifying employees as exempt or non-exempt under state and federal law is really important. There are a couple of states that have higher wage thresholds than the federal $36,000 and change threshold, right? Washington State, California, there are a couple of others that have higher exemption salary basis thresholds. So you need to make sure that you comply not only with the salary basis and the duties test, because some states have little different duties tests, for those white collar exemptions and computer professionals. Make sure that you go through that process every time you're looking at a position. What's that person actually going to be doing? Do they have the type of authority that they need in order to qualify for those positions? Because that's where you really get wage and hour problems, right? So for example, and I'm going to pick Colorado, not California. I'm going to pick Colorado. Colorado's meal and rest breaks, if you misclassify someone as exempt in Colorado and they're non-exempt, you've now missed all of those meal and rest breaks probably because you're not tracking time, right? And Colorado is really aggressive at enforcing these things. You might have missed other things because you've misclassified somebody. So it's really, really important. Same with independent contractors. You cannot just decide someone's an independent contractor. They have to meet the tests. The assumption is always that a person that you hire is an employee and that they're paid by the hour and entitled to overtime unless they fit into an exemption from overtime or unless they fit into an independent contractor test. Various states have more restrictive tests than the federal tests for making someone an independent contractor. That includes, of course, California, but also Massachusetts, New Jersey, DC. A number of states have more restrictive tests that essentially require that the person not be performing work that's in your immediate line of business in order to qualify. And the fun thing about independent contractors is it's not just the wage and hour tests. It's the unemployment test because states want their unemployment money, right? It's, Hawaii has different tests based on for their insurance for their health insurance program, for their unemployment insurance program, for their wage and hour program. So you need to make sure that you're meeting those requirements. Maryland's unemployment, for example, they say if your independent contractors don't have a website and a business card, they're not advertising to take work on for other people, so they're not independent. I don't care what agreement you have in place with them. They're not an independent contractor because they don't have a business card. So those are things you need to be thinking about when you're classifying individuals. Okay. Can't believe we only have 15 minutes left, Sarah.
Yeah, the time has really flown by. We can do it. So we talked a little bit, and I know we've gotten a couple questions about paid sick leave because it is a headache. It's a nightmare. But there are ways that you can navigate it. As a reminder, every state sick leave law out there, just had to make a quick sort of mental note in my head, allows you to satisfy the sick leave obligations with your PTO policies to the extent that those PTO policies are consistent with those paid sick leave requirements. What does that mean? That means if your accrual rate is satisfying the state sick leave or requirement, if your carryover policy is consistent with that sick leave policy, if you allow employees to use the PTO for the state sick leave permissible reasons, and a few other handful of requirements, your PTO policy can substitute in there just fine. Where we sometimes find issues with certain PTO policies that are trying to satisfy state sick leave obligations is maybe there's an exception, you don't give it to part-time employees. Pretty much every state sick leave law requires that you provide part-time employees with those sick leave accrual rates. We also see it where there's a cap on carryover. This is perhaps one of the most frustrating things I think about different sick leave laws is they all have different rules on what a company can limit. Some states say you can limit use. So you can have this sick leave in your bank, you just can't use more than, I don't know, 56 hours in a year. Other states say, well, you can't cap use, but you can cap carryover. So you can cap your carryover to 80 hours every year. Other states say, no. Wait, you can't cap use, you can't cap carryover, but you can cap total overall accrual at any one point in time. This stuff is very frustrating. But there is a way, basically, you look at all your states, you figure out what the rules are. You can either draft something that is all inclusive and covers all your bases, or you can draft something on a case-by-case basis that satisfies each state's requirements. And I think that part of a few years back, we started recommending that clients use state addenda because it's just too hard to address everything in a handbook. And it's easier just to say, here's your handbook, here's an addenda for your state-specific policies. And I think part of the reason for that really was the sick leave. That's one of the first ways that we saw states really start to differentiate in terms of how they treat employee terms and conditions of employment. We've also seen a few states go a step further beyond paid sick leave. They're now requiring paid leave generally. That has not been very popular in years gone by, but it seems to be a growing trend. So not just do you have to provide sick leave, but you have to provide generally leave for your workforce. Just a handful of states so far, but that is something that we're seeing sort of trending in a certain direction. There are also different limits that can pop up depending on requesting a doctor's note. Obviously, this plays intricately with other state laws that Nichole's talked about with respect to sort of medical leave, family leave. Important to see how those play together. And also remember that it's not just the states, it's localities. So cities, Montgomery County, they have even additional requirements that they impose, which can just complicate things a little bit further depending on where your folks are located.
Yeah, I was surprised there's one state in particular that does not allow you to request a doctor's note for 4 days. Normally it's 3 days. Yeah, and so you know, we deal in these kinds of questions every single day, but I know some of the questions have really been focused on, well, like, how do I keep up? Even if you have a service that provides like handbook updates, there are certain things that won't necessarily go into a handbook or that you want to deal with in a certain way that you should always double check, you know, like when at the time of termination, or, you know, if you have specific questions that may not be fully addressed, or that's, you know, an employee has a question on, double check it, because never ceases to amaze me that I'm like, oh, when did that change, right? So it's just really hard, even if you're capturing all of the high risk stuff, every now and then you see something funky, you know, gut check it, make sure you're doing it right. You know, because there are a lot of, you're trying to make, most clients are trying to make all of these things fit together. For example, somebody on this webinar asked about PTO policies and whether paid sick leave can satisfy those. Most of the time, yes, but you need to make sure often that you have the cap carryover accrual kind of buttoned down if you need to in certain states. And sometimes you're going to make risk decisions about whether or not you can make it all work together and what states you might be willing to take a little risk in, because operationally you can't manage, 15 different systems for sick leave. Another question we had, Sarah, was if PTO is front loaded at the beginning of the year, do I satisfy my carryover amount? Not usually. It usually satisfies the amount of leave that you need to provide somebody in a given year. But if the state also has a carryover requirement, like you have to allow an employee to carry over any sick leave that they might have accrued, and you're in a state that recognizes, let's just say 48 hours of sick leave a year, you need to make sure that your PTO policy allows for at least 48 hours of carryover, even if you front loaded the full amount a year. Would you agree with that, Sarah?
Yeah, some states make it easy. They say if you front load, don't worry about the carryover, but not the majority. So just like with the sick leave executive order, you don't satisfy those obligations by front loading and then having everyone start at square one. It's one of the reasons we don't generally recommend the front loading approach. So unfortunately, that's not always the easiest way to get around that.
Yeah. And then you have, like we talked about, all of these kind of protected leaves. That doesn't necessarily mean they're paid, but you need to kind of determine which state you're in and whether there's, if there's family and medical leave in a state, even if you're not FMLA qualifying, does that mean there's also a state insurance program? Is that job protected leave? Is it not job protected leave? You need to kind of get a handle on that. And it's always a good idea to think about up front how you're going to manage that leave and whether or not they can use PTO for it. We have a lot of clients moving to flexible or unlimited leave policies. So it's performance-based work. They don't want to deal with any of this stuff anymore. So they just say, well, just take the amount of leave that you want, which can work really well in some industries or with some groups of people within a company, because the work is more performance-based or billable hours-based work. There are some things that you need to watch for, like there's some ambiguities in Illinois with respect to vacation payout and how you handle that. You need to be thinking about, well, if I have an employee that gets cancer, how much leave am I willing to pay for? I don't want to be in a position of having to terminate them after a certain number of weeks. So at what point in time do they go on our short-term or long-term disability? How does that fit with the unlimited leave policy? How about some of these family medical leave, organ donor leave, voting leave? Is that all going to be covered, right? So you have to anticipate those things and figure out in advance how you're going to handle them so that you don't end up treating employees differently. But it seems to be on the rise. People tend to really like those policies.
I hate them, for the record. I am not a fan of it, but that is outside the scope of our. Anybody wants, you can give me a call. Additional wage and hour concerns. Okay, so there are some other things that, and this is really just this is Nichole and I sitting down and thinking, where does this come up, and what is our first question? If our first question is, where is this employee located? That's generally a good indicator that these things are, so state specific. And another question is often like, what's the risk? Nichole touched on this earlier, I think, really eloquently. But this issue of, we don't need perfect to be the enemy of the good by any stretch of the imagination, right? But what we do want to do is avoid costly mistakes. And wage and hour areas are one of those areas where class actions can be a really big threat. Attorneys' fees can rack up really quickly, and there can be certain penalties that attach right out of the box. So even if you made an honest mistake, you try to go fix it already, that's costing you money. So just thinking about the high risk areas. Wage and hour considerations are a big one, timekeeping. In certain states, it's really important that you have, all states, I think it's really important that you keep good time records. But in certain states in particular, you need to make sure that employees are clocking in and clocking out. And those tend to be the states where it's also important, not only are they clocking in when they get in the morning and clocking out when they leave, but they're clocking out for their meal breaks, anytime that they are not performing work. And I know as a lot of government contractors kind of navigate this, you're used to maybe if you are DCAA compliant, you already have a really like close view of timekeeping, but it's so important in pretty much, and I think it's getting more and more important, to just make sure that people are clocking in and clocking out. Just writing 8 hours, at least for your non-exempt employees, those are those hourly employees who get paid overtime. Just writing 8 hours is not going to cut it anymore. You need a good timekeeping process. Also, states like Colorado, California. Nichole, you just mentioned a new one that added to the mix. I can't recall. Minnesota. Okay. So yeah, the number of states out there where you need to really make sure that employees are tracking this. And meal breaks are not generally paid unless you've got some unionized setup for your non-exempt employees where the CBA controls. But it's important that you're tracking this. And there are certain, sorry, I'm throwing my pen across the room. There are certain just best practices to follow. Just keep those in mind, because if you don't, you could end up with a wage and hour class action. And it's really nice to avoid that if you can. Just really straightforward steps at the beginning to make sure that you're not digging out at the end. It's also just important that you make sure you keep track of where folks are located, because there have been more, I'd say more and more calls we've gotten where like, oh, you know, this employee, they just informed me that they've moved to Portugal, or they decided they're going to work from Brazil for a year, or they've decided they're going to move to California and they're just doing it. And it's just important to figure out how you're going to deal with that in advance of maybe an emergency popping up where you've got to all of a sudden recreate all of the meal breaks that this individual had because they've been working out of California for the last 6 months. And then Nichole, I think you're going to talk about bonuses and deductions from pay.
And we're going to scoot through the next few things because we're on the tail end. But basically, bonuses are state specific. So every year around this time, employers call me and say, well, so-and-so provided their notice and I don't want to pay the bonus that I was going to pay them next week. Your bonus policy will play a great deal into whether or not you can do that, but also state law will. For example, in Maryland, if the employee has done everything they're supposed to do to vest in that bonus and to receive that bonus, so if you calculate your bonuses on an annual basis and they put in their notice in January, even if the bonus isn't paid until March, you owe them that bonus. So think about it as something they earned for last year, not this year. But the language in your bonus can play into whether or not you have to pay that in many states. So pay attention to that language. If failure to pay is a wage and hour violation. So if you're in a state that applies double or triple damages for failure to pay that bonus, that can be a big deal. And then we're always watching for deductions from pay, right? At the end of employment or during employment, do we need a very specific deduction form, not just a general, I can deduct whatever I want, whatever you owe me, but a lot of states have requirements for the amount that's owed, the specific thing that you can deduct for, if it's a voluntary deduction, how much you can deduct, can it go under the minimum wage? So we're always looking at that issue as well.
We'll do really quick employment termination issues because let me just make sure. Yep, we're almost at the end, everyone. So employment terminations is also where a lot of the wage and hour quick questions come up. You've got final pay considerations. A lot of states require pay sooner than the next regularly scheduled payroll. Like DC, for example, you got to pay within 24 hours, depending on the relationship with the employee and whether it's a resignation or a termination. And these are areas where it can, again, be costly if you get it late because there are damages that apply, and it's best to just be on top of it. Same thing goes for California and a growing number of states. There's a number of states in the Northeast that have their own unique little quirks. So just important that you've talked about that with your offboarding folks. Also, vacation payout. Vacation generally is this question of whether vacation is a wage that's owed. There are a handful of states that require that you pay out PTO regardless of what your policy says. If you're in a place like Maryland, they require it if you don't explicitly say you don't pay out. So just making sure that you're clear on what the laws of the states where you're operating are, your folks are located, and your policies and procedures. Because part of this is, just because we're stating what the states permit doesn't mean that you have to, go to the lowest common denominator, but you should be making strategic decisions about where you want to, put money, how you want to invest in employees, and just make sure that you're familiar with those obligations. I think that's it for vacation payout issues and final poll.
If you want, if you're going to engage in providing a severance, or you're giving an employee something, or you're giving up something, you might want to consider a severance agreement or release agreement. There are several things that can and cannot be included in severance and release terms, or things that you should have to make sure that those are enforceable. If you haven't updated yours lately, it's a really good time to do it. And of course, we mentioned mini WARN acts. So if you are laying off, a number of folks in any given place, you should be checking to see if a mini WARN act applies, because it can have significant penalties and requirements for notifying employees what needs to be on that notice, letting the state know. Yep. And then we had a question about mini WARN and how would it impact you as a government contractor with government shutdowns? Great question. There is a difference between a stop work order and a contract coming to an end. So one thing I think is even riskier is when contracts come to an end and employers don't have a reasonable sense that they will get a follow-on contract, and they just assume, well, like the next contractor will pick up the workforce, it'll be fine. But technically you have noticed the contract's coming to an end, mini WARN can kick in there. So be aware of that. We saw, we saw a lot of this during like the USAID stop work orders. That's very similar to government shutdowns. The question usually is, do we expect this to be longer term? It's not usually a layoff until a certain point in time. Sarah, do you have something you want to add there? I mean, we're talking about a week shutdown. It's usually not a
generally. So the WARN Act, and every mini WARN Act is different, but at least on a federal level, it's only if you are anticipating a layoff lasting more than, and this is the part I would need to double check, but it's either 30 or 60 or 90 days. And so in most cases, if you're anticipating the stop work order to stop, you're fine. It's where you anticipate it to last longer that those obligations do kick in. And the penalties are really frustrating. Like if there's a WARN Act case that's filed against you, it is frustrating. So it's worth getting those notices out to both employees and to the officials who need to be notified. It's a pretty straightforward process.
And just because you don't have 60 days to give someone in advance because whatever the case might be, that doesn't mean you shouldn't give the notice. Like as soon as you think you're going to need to give the notice, right? So, and that might be an ongoing discussion with, us or your legal counsel about how to handle it. But it usually is meant for this expectation of more permanent layoff. So that's really what we're talking about. And then just high level, you can go through this last slide. I think our theme of the day is really putting in solid standard operating procedures to help you organize how you're going to manage changes. And we did have this question earlier, but I like to have clients consider once or twice a year looking for those updates. Of course, make sure you're on some good listservs, SHRM, your payroll companies often have updates. So you'll see them come through, but it's easy to be kind of in this barrage of information, right? Everybody's looking for a click. So if you find some regular time periods to more methodically check and see if you need to update something mid-year, what point in the year are you going to do a handbook update? How are you going to manage it operationally? What standard operating procedures do you have in place when you are thinking about things like new agreements, terminations? Having those good standard operating procedures to double check is really going to save you time and money. And that's all I have. Sarah, anything to add?
Nope, I think that's it. It's a miracle. We got through the whole webinar in the hour, almost the hour.
Almost. And we appreciate those of you who have hung out with us for the extra 4 minutes. Again, if you are not on our listserv, we send out a weekly update. And please let us know what topics you would like to hear about from us, because we are here to give you information. So it's not just about what Sarah and I like, it's about what you all want to hear. So thank you all so much and have a great day.
Bye, everyone.